70 WOCA.
Ocala.
"25 minutes before 11 o'clock, John Fuller is in the studio. He is an attorney here in Ocala. His law firm is his law firm. It's called Fuller & Fuller. The other Fuller is Janet Fuller, his beautiful wife, who we haven't seen in a long time, by the way. And, in fact, we don't always see John. A lot of times he's in court and cannot come in. But today, on March 13th, this is a live show. So if you're listening on March 13th, then we invite you to call in. The number is the WOCA Climate Control Source Hotline, 622-9622. And John is welcoming your questions regarding your legal situation, even though we might expand beyond that a little bit today. Good morning, John.
Good morning, Larry, and good morning to our friends who are listening to the show. It's good to be here. It's got some real beautiful spring weather out there, although it's getting a little chilly at night, I understand. But we're happy to be here. We have had some absences lately, so this is a live show. If anyone has a legal question, they can call us, and we'll try to talk with it. In general terms, we handle areas in our law firm, Fuller & Fuller, of accident cases, business commercial litigation, complex, substantial family law matters, and of course Janet Fuller, my wife and partner, specializes in Social Security disability work and does that exclusively. So if you have a problem, or someone in your family or friends who's been involved in an accident or who has a legal question, we're certainly happy to schedule an appointment and deal with the case in a one-on-one basis. But this show is a wonderful opportunity. We have some great listeners who call in with great questions. This is an interesting time of year for the legal system, the judicial system, because the Florida legislature is in session. And
yes.
Every year they go up and meet, and thousands of bills are filed, and some of them get passed, many of them at the 11th hour of the last day of the session, like the PIP bill, the Personal Injury Protection Bill, that has potentially wreaked a lot of havoc on individuals who are maybe injured in accident cases. We've talked about that throughout the year. That thing was ramrodded through the legislature by the governor at the 11th hour, and certainly is an issue that has had great discussion and debate. And continues to, but they're up there in Tallahassee, and new laws are being developed and working its way through the system, and some are certainly good and necessary to keep pace with society and what's happening. Others, I think, we'd be better off if we went back to the system we had about 20, 30 years ago or longer, where the legislature only met every 2 years. So that may be a personal opinion, but I see we have a call.
Yes, sir. Good morning. You're on the air with John.
Good morning, Mr. Fuller.
Hey, how are you, sir?
Pretty good. I was sorry I didn't get a chance to attend the tribute to Sheriff Dean yesterday, but since I'm no longer able to drive, it's hard for me to get around, but I understand they had a good turnout. Were you there?
Where is that, sir?
At the Livestock Pavilion, a tribute to Sheriff Dean yesterday.
No, sir. We had a high school baseball game in our family, and that takes precedence over all other activities. When that happens, when the schedule has one of those this time of year, that's a priority for our family over just about every other thing we have.
And it should be. I had a son that was on the Vanguard High School football team when he was in school, so I can understand that.
That's great. It's a fun time. It's a good time, and we're grateful for it. And I know you enjoyed that when you were a participant.
Oh yeah. Okay. Now I'm glad you mentioned the legislature, because yesterday I was watching some of the session on that Florida network that they do a pretty good job, Mr. Lilly. But I see where now. And my concern is, how in the world are they going to do this? I see where now they're trying to get rid of some of these special districts, like the water districts and mosquito districts, that have, taxing authority and those types of things. And I see where they also are trying to exclude some of the districts. I think they even have one in there for special or home association districts and stuff like that. My question was, how do you think that they're going to have any legal problems if they get rid of some and some they don't? I'll hang up and listen to your answer on that.
That's an excellent question, and I have not, I don't think any one person could keep up with all the bills that are filed and pre-filed. That's why lobbyists are paid hundreds of thousands of dollars a year to focus on legislation that might affect their particular client who has a special interest that they are trying to protect. So I certainly don't have a grasp of all the legislation that is fermenting in Tallahassee as we speak, but you raise a good point, and I will make one observation and one legal principle. The Florida law does not allow the legislature to pass a general law for local application. Now, there are exceptions where they can have local acts, and we do have local taxing districts. The hospital is one that has a law that passed that allows it to be a special taxing district and that sort of thing. And people who specialize in governmental law and municipal corporate law, this is an area that they deal with and that they're very knowledgeable of. It's not an area that I practice in, but you are absolutely right to say, to raise the question, might not there be some constitutional issues in laws that are passed that are general laws of local application? And that is absolutely correct, and the courts have held that the legislature cannot do that except under certain very, very specific circumstances, and have held many of those laws unconstitutional and unenforceable. So yes, I think so. Mm-hmm. I also am aware that there's legislation pending. I don't know the details of it, but trying to deal with unification of the statute dealing with lot owner or homeowner associations, which has developed out of a very real problem. We all know that 4, 5, 6, 7 years ago, we were in a real estate boom market, right, where everybody that was just anybody and everybody was getting into the development business, and they were going out and buying land and speculating and hoping to flip it, and they were establishing subdivisions, selling a few lots. Usually the incorporating agreement says that the developer retains majority voting rights as long as he has a majority number of lots. Sometimes he gets a weighted voting average, and that offends and there have been cases, not all situations obviously, of abuse where a developer would develop a subdivision, market it with all types of amenities, a recreational facility, community swimming pool, jogging trails, sidewalks, etc. And he sells a couple of lots, and then he goes belly up, and the next thing you know, he owns all the lots. He controls all the votes, so he votes to modify all that. And the people who bought their lots in reliance upon that have grievances. And there are a lot of other examples like that. So legislature's trying to fix it. I read one article that said that the bill that was currently being put forth, while it's an effort in the right direction, falls short of doing what needs to be done. I don't know any of the specifics, but that's one bill.
And you have to keep up with that. I mean, if you have a client coming to you,
if you're in an area, what I try to do is to monitor carefully those areas of the law that I regularly practice in, and to try to keep abreast of the legislation that might impact the people that I represent in the areas of law that Janet and I practice in. One of those we talked about, Larry, just before the show started, is that a number of legislators, I suspect they are disgruntled ex-husbands who the judge ordered them to pay their spouse permanent alimony.
I think you're right.
Have again sponsored a bill. They did this last year and it did not get out of committee, but they have sponsored a bill that would make it unlawful for a court to award permanent alimony to any recipient spouse under any circumstances. Just completely do away with permanent alimony. The Florida Family Law section of the Florida Bar, the Florida Matrimonial Lawyers Association are all in opposition to that law, and there's some interesting issues we can talk about later. I see we have a call.
Yes, sir. Good morning. You're on the air with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning, sir. How are you?
Very good, thank you. Several years ago, we had some very close friends who took a trip to Las Vegas. I'm going to make this as short as I can. It was a very windy day there, and as they were entering one of the casinos, a part of the sign blew off and struck his wife. It was not a major injury, but she was hospitalized for a couple of days, and as the story goes on, the casino is going to offer some kind of a minimal payment just to keep them happy, more or less, and it turned out that she had to have continuous, even up to this day now, she still goes to a chiropractor and gets shots for this, that, and whatnot. They obtained a lawyer, and it went to court. It was in court for a long, long time, and it turned out to be the final decision was called an act of God. Now, can you explain to us just exactly what that is, and can that be contested?
Well, certainly any ruling of any court can be appealed if the error is properly preserved and the appeal is timely taken. Now, I assume, since she was injured in Las Vegas, that this claim and lawsuit was filed in the state of Nevada.
Right.
Every state's laws are different, and I certainly would not pretend to have any specific knowledge about the laws of the state of Nevada. An act of God, in its simplest terms, is that when there is an intervening event that is beyond the foreseeability or the control of the person who is being charged with negligence, that it can be asserted as an affirmative defense. And if a jury is convinced that the causation of the injury was not due to foreseeable negligence by the part of the defendant, but was due to some extraneous intervening cause, thunderstorm, lightning, tornado, things of that nature, then that is a theory in the law that one can assert. You don't see it very often, and it is even more rare to see it successfully asserted. I have had several cases during my career where people have been injured by items in stores and affixed to stores that spontaneously fell and hit them. One of the larger cases earlier in my career, a lady was shopping in a large department store here and was in the automotive hardware section, and she leaned over the counter to pick up an item that she was purchasing for her husband, and they had a number of automobile tires hanging from a pegboard above the counter on a display. And just spontaneously, one of the clips that held the big rubber tire, I don't remember whether it had a wheel in it or not, but it was still sufficiently heavy. As she was bending over the counter, it fell, hit her in the back of her neck, and then also pivoted and hit her in her low back, causing ruptured disc both in her cervical spine and her lumbar spine. And she had She had multiple surgeries on it, and did not have a particularly good result. Was left with residual pain, loss of range of motion, inability to enjoy her activities of daily living.
Yeah.
And we had a jury trial here in Ocala at that time. Which, to tell you how old this is, it was like 1974. There had never been a jury verdict in Ocala in excess of 6 figures, because Ocala was a very conservative place.
Right.
Of course, a dollar was worth a lot more 39 years ago than it is today. But nevertheless, it was impossible to get anybody to make you a 6-figure offer here, because they said, well, there's never been a verdict in excess of that.
Yeah.
Well, this case was tried for a week, and while the jury was deliberating the case, it was settled. And although the amount wasn't made public and was not published or anything like that, our client was very satisfied.
Okay. That says everything.
But when people have injuries, major injuries, life-altering injuries, there's no one I've ever represented who wouldn't give every dime of the money back if they could just be whole again.
I think you're right. Yeah.
That's a point that bears in mind. But I tell juries, it's the best our system has to offer. You don't have a magic bullet or a magic wand that you can restore Mr. or Mrs. Doe back to good health and well-being. The only way our system can compensate is through money damages.
And
yes. Thank you, sir.
Another phone call. Good morning. You're on the air.
I wonder if Mr. Fuller might please express his thoughts on flood insurance and flood zoning. When a property is decided to be within a flood zone when it had not previously been, then what? And what are the insurance and other implications? Please.
Well, thank you for your call. I'm not sure that there's a lot that I can say about that. Insurance policies is a publicly sold commodity, and they can draft the language they want, and if you don't like the language, hopefully you can find another policy with another company that is more risk tolerant than what you're saying. Generally speaking, governments establish a floodplain, and insurance policies then track these these provisions adopted by government as to what location is considered in a floodplain. And if you're building a building in that area, they either refuse to give you flood insurance, or if it's available, it is available for a substantially increased premium. And if you are building a new structure in order to get it insured that is in a previously designated floodplain area, it has to be built to certain specifications. We don't see too much of that in Ocala because it's in the central part of the state. When you get over on the coast,
probably see a lot.
If you're building a new construction, for example, in the Florida Keys, you have to basically build the first floor on pilings, concrete pilings, that you're not living on the first floor. You can use it for your garage or storage or workroom or what have you, but you have to have it elevated 1 story above the ground, which is then theoretically puts you above the floodplain in the event of a hurricane.
The example you gave of the tire falling on the lady, that obviously fell without any earth shaking. But what if it fell because of an earthquake or like a slight tremor? Would the results have been different, would they have then said that was an act of God? And
well, that goes back to what the first gentleman called and said. It goes back to a measure of foreseeability. An earthquake here in Florida would be a very, very rare occurrence. A hurricane would not necessarily be such a rare occurrence. So its question would be, in my judgment, based on just general conversation, is the event within the foreseeability of a reasonably prudent person? That's the one of the
and
tests.
Somebody decides on that.
Well, ultimately, a jury would decide what is foreseeable to a reasonable individual. One of the things, we joke a little bit on the show about the old vestigial Latin phrases that still are in our judicial system, and you see it in the medical system too. If you ever look at your prescription and you see medical scripts written out, they'll say take one pill HS. Well, HS is Latin for asinorum, which means at bedtime.
I didn't know that.
And AC is before meals, anticipo, which is comes from the Latin. Well, and the law has it too. And one of the theories that we used in that trial was a theory known as res ipsa loquitur, which translates from the Latin meaning the thing speaks for itself. And that is that it shouldn't have, there was no reason that the tire, if it was properly installed, should have fallen off the wall. And if it did, the mere fact that it fell was sufficient proof of negligence because the thing spoke for itself. And we got a jury instruction on that.
Oh, that's too funny. Going back to the proposal to do away with lifetime.
Yeah, that's.
I know there's not much time to talk about.
That's a great issue because, first of all, only a relatively small percentage of divorce cases is permanent alimony awarded. The legislature says that there are various presumptions. The law has codified this now. And if you're going to get an award of permanent alimony, the court, first of all, has to find that it's a long-term marriage, which by definition in the statute means it's longer than 17 years.
Oh, wow.
Then the court has to determine that the recipient spouse who is getting the permanent periodic alimony, that there is no other form of alimony that would be sufficient to adequately provide for her, and that I say her, it could be he, male or female. It's gender neutral, and I apologize for using the feminine of that. It says that the spouse, the recipient spouse, and it's male or female are entitled to the same application of the law. If the recipient spouse is able to convince a court to award permanent periodic alimony, they have to prove that they have the need, the other spouse has the ability, and that there's no other form of alimony that would be sufficient to provide the necessary support for the recipient, and the judge who awards it has to make specific evidentiary findings of fact that supports that award. Also, an important thing that I think that people should know is that permanent alimony, even though that's what it says, does not mean forever. Anytime alimony is awarded in any kind, in most cases, there may be some exceptions, but in general terms, the court reserves jurisdiction to modify that alimony, either to increase it or decrease it based upon a substantial change of circumstances that might occur in the future.
Really?
So if a spouse gets divorced, and at the time they get divorced, they are completely destitute, impecunious, they don't have assets, they don't have income, they don't have the ability to earn, to be self-supporting, and the other spouse does have sufficient assets, income, resources to pay alimony, and the judge awards permanent periodic alimony, that is payable until either spouse dies or the recipient spouse remarries. Okay, that's the definition of permanent alimony. Now, let's say that was awarded, and after permanent alimony was awarded, the recipient spouse went back to school, was not expected or anticipated that he or she either could or would be able to do that, but let's say they do. And let's say they get a college degree and they continue on and they get a law degree or a medical degree or something like that, and 10, 12 years after the divorce court originally awarded permanent alimony to them, they are now a practicing physician, a practicing doctor, a practicing CPA, making a substantial income. Then the spouse who was ordered to pay permanent alimony can go back to court and say there is a new set of circumstances, a substantial change that was unknown, unanticipated at the time the court awarded this, and that justifies a modification. I'm entitled to have my permanent alimony either terminated or substantially reduced. One of the other factors that is in and of itself constitutes a substantial change of circumstances when a payor party, someone who's obligated to pay permanent alimony, reaches normal retirement age and they slow down or retire, and their income in retirement is less than what it was when they were practicing their profession or engaging in their job. Just the mere fact that they reached age 65, say, that in and of itself constitutes a substantial change in circumstance that allows the court to take a look at whether or not it needs to modify permanent alimony. So it seems to me a pretty heavy-handed tactic to take that tool away from judges who I've found them to be very, very judicious in awarding permanent alimony, and the Florida Bar Family Law Section and the matrimonial lawyers are opposed to this law. Yeah, I know a guy in New York who is working for his ex. put it that way. He's paying a lot. John, what's your phone number? Our office number in our Ocala office is 352-547-4292. We have a toll-free number, 855-534-2565. The law firm's Fuller & Fuller. We have offices in Ocala and the Villages. If you have a legal case or claim in an accident or business commercial matter or complex family law or Social Security disability, those are the areas that we practice in. We'd be happy to talk with you. Excellent. And if you missed any of that and need it repeated, call us here at the radio station. We'll be glad to do that for you. John, good to see you again. Thank you, Larry. Always a pleasure, and thanks to all our listeners who called in. Always interesting. We'll take a little break, and we'll be right back.
Ocala's information station, 1370 WOCA. Ocala.
ABC News Now. I'm Daniela Bellotta. Instead of making a hole-in-one, he was in a hole himself. A golfer was nearly gobbled up by a sinkhole. Mark Myhall was sizing up a shot at Ann